range of relationship arrangements, that although registered partnership and marriages are comparable in terms of legal relations and legal consequences, those institutions still cover relationships that are basically unequal. Then 2.5.
So, Miss Luthra,
Yes,
there was a separate body of law which permitted these civil relationships to be, registered. So first there was a body of law like in England. In England also there were civil partnerships from 2004. Now this is that kind of a situation where there is an pre-existing statutory platform. Now what is not very clear is when was this law enacted? Was it in 2009 or even earlier? Because it does refer to personal law, section 8, etc.
Yes, my lord. And I believe it was much earlier. I'll just answer your lordship.
No. Please turn to page 2, para 2.
Lord, 4.
At para 2, at page 1087 of the PDF.
Para 2.1 actually says that same-sex couples can enter into a registered partnership pursuant to the Registered Partnership Act.
That's right.
I just want to draw the attention of the court to the excerpt of the Federal Act on the Registered Partnership Federal Law Gazette 2009. So this law was enacted apparently in 2009 and later amended in 2015. That is para 2.
Yeah.
That's right. That's right, Lord.
Now please,
Lord,
proceed.
grateful, my lord. My lord, 2.6, I'm skipping 2.5 because of paucity of time. And so, my lord, 2.6, the distinction in the law between opposite sex and same-sex relationship as two different legal institutions thus violates the principle of equality, which forbids any discrimination of individual on the ground of personal characteristics such as their sexual orientation. So even the requirement to disclose that you will come under partnerships, even though you get the same gamut of rights, was itself considered to be discriminatory. My lord, going on 3.2.
But
fact,
so, Ms. Luthra, even on issues such as adoption and medically assisted procreation, there are specific legislations in Austria. So, if you look at the bottom of page 1081, they say that recent developments in law allowed in particular joint parenthood also of same-sex couples. See in particular sections 191 and 197 of the General Civil Code, and use permitted forms of medically assisted procreation on an equal footing, namely Reproductive Medicine Act, Federal Law Gazette, 1992, as amended.
Yes,
in the next page.
This is like two systems of law. See, this is let us understand the background. This is a civil law country where, keeping aside considerations of personal law emanating from different parties' religions, we don't know how much of plurality exists in that society. Keeping aside that, this is more of an issue of classification, where they say that you cannot really treat them as separate classes. Now we are at a more fundamental stage. We have not legislated. So you want us to get into the second phase and say there is no classification. Yes, there is actually no classification as of now.
And basically, what I'm asking is that even that was invidious of the equality interpretation. The fact that they had all the bundle of rights, whereas I have no right. I have no right. I want recognition of my marriage as an incident of 14, 15, 19, and 21. So the fact is, yes, we may be jump starting, but we are too late in the day. We have to come to that stage. We are already too late. India can't be lagging behind so much. Our jurisprudence is being seen all over the world. But here we are lagging behind the others. And we cannot deny our minorities, my lord. So your lordship is right that there were already two parallel institutions. But see how far they go, that even parallel institutions can't go. So in this case, what I'm saying is, I'm only asking there should be one institution. That's marriage. And I want that right.
Rights are no less.
And my lord, what the court finally interpreted was, we are leaving both and let either side enter into either, so that even same-sex people can get into marriage, even heterosexuals can get into registered partnership. That's what the conclusion of the court was, which is so beautiful.
Just see para 2.6. That's what you are really arguing.
That's right, my lord. That's right. That's right.
She's already arguing than any right we have. That's the point, I think. Is this a right? Navtej guaranteed this to us.
And my lord, Navtej had actually started the footprints, and we have to now give effect to it. We cannot be left halfway. We cannot be left with our rights being
in Austria, it appears that there were two different legal institutions created by law. Marriage for opposite sex heterosexual couples and a registered partnership for same-sex couples. So they said that this restriction, namely a registered partnership for same-sex couples, this is discriminatory. That seems to be the drift at page.
The walls, if I may say that, the wall separating the two was brought down.
Yeah.
Both kinds of both kind of relationships could go for either kind of relationship. Both type of couples, same sex and heterosexual couples, could go either for marriage or for civil relationships.
Yes, my lord. Yes, my lord.
Now see the result. The result that the relief which they grant gives us an idea of what was really the issue.
Yes,
The
my lord.
phrase of different sex in section 44 of the General Civil Code and the phrases of same-sex couples and of same sex in the Registered Partnership Act are therefore repealed as unconstitutional for violating the principle of equality.
That's right, my lord. And what it's saying, setting a deadline, whatever, the finding that earlier provisions shall not re-enter into force is based.
All right, I think, thank
We
you,
do-
Ms.
Yes.
Krishna. Now I think we'll wrap up at this, otherwise we'll...
My lord,
look
now
at the others,
as
with
far
the
as
others.
this judgment is concerned, this is over. May I just take your...
There's a South African judgment, National Association. Just briefly, maybe just one para we can see there.
My lord, the South African judgment, which is part of my written note, and my lord, what it basically is, the position was...
What's the
with
PDF
regard-
page? PDF page?
PDF page,
This is part 5.
part 5, my lord. It was with the note. So, my lord, it's just next to the
All right.
note,
All right.
this note. My lord, this case was preceded by the
Luthra,
form.
it's not part of volume 4, this national
No, volume 5, then with my note, It's national, no, not, is it volume 5?
There's no volume.
It's part of the written note that was just the 3-pager.
Yes,
Three-page one.
Yeah.
we've seen that, National Coalition for Gay and
That's-
Lesbian.
Yes,
That's-
yes,
Right, right, it's there, yes.
Yeah.
yes.
It's at page 4 of the note.
That's
Are you
Yes.
referring to a particular para?
Sorry, Milord?
Any para number?
you can give the
Yes.
Your ladyship, the
Paras which we are relying upon, and we are emphasizing are 49, 50, 51, 53B. I want to read some of them, 55, 56, 62, 67, 71, and 72.
Just give us the best paragraph. Let's go to that.
Yes, my lord, can I just give the background? That it was basically an interpretation of the Aliens Control Act, which was the immigration law.
Okay.
My lord, I'll just give a little background, then I'll just read out 3, 4 of the important paras and be done. My lord, 25(2) of the Aliens Control Act said that it permitted foreign heterosexual spouses of permanent South African residents to apply for immigration permits, but not to foreign permanent same-sex life partners of such residents. So in that sense, it's para materia to the petitioners herein.
Just read out.
And the court said that it was an unfair discrimination. So if I may take my lord to, your lordships to,
What's most important?
para 53B, and then how it's to be read down. I will just read that.
PDF page 34.
PDF page 34. Para 53B. Just shorten.
Just read this.
The subsection is, have your lordships got it?
Yes.
Yes.
The subsection in this context, in effect, states that all gay and lesbian permanent residents of the Republic who are in the same sex relationships with foreign nationals are not entitled to the benefit extended by the subsection to spouses married to foreign nationals in order to protect their family and family life. That is so stated, notwithstanding that the family and family life which gays and lesbians are capable of establishing with their foreign national same-sex partners are all significant aspects indistinguishable from those of spouses, and in human terms as important to gay and lesbian same-sex partners as they are to spouses. 54. The message and impact are clear. Section 10 of the Constitution recognizes and guarantees that everyone has inherent dignity and the right to have their dignity respected and protected. The message is that gays and lesbians lack the inherent humanity to have their families and family lives in such same-sex relationships respected or protected. It serves in addition to perpetuate and reinforce existing prejudices and stereotypes. The impact constitutes a crass, blunt, cruel, and serious invasion of their dignity. The discrimination based on sexual orientation is severe because no concern, let alone anything approaching equal concern, is shown for particular sexual orientation of gays and lesbians. Then, my lords, I just think I should just go to the manner in which it has been read in.
Page 36 of
The appropriate remedy,
36.
page 36,
The PDF.
para 62 of the PDF. What is the appropriate remedy, my lord? It's under appropriate remedy. My lords have it.
Yes.
62. As far as the declaration of invalidity is concerned, the High Court considered that 3 options were open to it. The first was to remedy the constitutional invalidity of 25(5) by introducing reading in words into the section in such a way that its provisions also applied to persons in same-sex life partnerships. The High Court decided against such remedy as an appropriate one, principally because it was of the view it was not possible to define with a sufficient degree or precision the words that had to be inserted in 25(5) in order for it to comply with the Constitution. The second was, my lord, can I just take your lordships to 67, just to precede the time, and I'll just point out the paras that I'm emphasizing at the end of the
39 of PDF.
39 of PDF, para 67. I am persuaded by Mr. Ten Gove's submission that as far as deference to the legislature is concerned, there is in principle no difference between a court rendering a statutory provision constitutional by removing the offending part by actual or notional severance, or by reading words into a statutory provision. In both cases, the parliamentary enactment, as expressed in a statutory provision, is being altered by the order of a court, in one case by accession and the other by addition. My lord, now para 82, PDF
43.
43, PDF 43, para 82. An appropriate remedy in the present case must vindicate the rights of permanent same-sex life partners to establish a family unit that, while retaining the characteristic features derived from its same-sex nature, receives the same protection and enjoys the same concern from the law and from society generally as to marriages recognized by law. But it must vindicate at more than an abstract level. It must operate to eradicate these stereotypes. Our constitutional commitment to non-discrimination and equal protection demands this. Now, my lord, just after reading that, the most effective way of achieving this in the present case is by a suitable reading in, if this is reasonably possible. So, my lord, as far as this judgment is concerned, may I just re-emphasize the paras, because I couldn't read all of them since I have to keep to some time limit. Paras 49 to 51, 53 to 57, 64, 66, 67, 73, 82.
Actually, 86, they read in the words
Yes.
after spouse, they read the words or partner in a permanent same-sex life
That's-
partnership.
That's right.
Because what you could get an immigration permit for a spouse. Now, spouse is interpreted to mean a heterosexual spouse. In para 86, they say we will expand that by reading the words or partner in a permanent same-sex life partnership.
So, my lord, in para 97, they give the final summary, and then in 2.1 of 97, at the para 97, 98, I'm sorry, of 98, the omission from 25(5) of the Aliens Control Act, after the word spouse of the words or partner in a permanent same-sex life partnership, and my lord, I would say LGBTI, whatever, partnership is declared to be inconsistent with the Constitution. And then the next page,
2.2.
2.2, 2.2, section 25(5) of the Aliens Control Act, to be read as though the following words appear therein after the word spouse or partner in a permanent
Right, I think, Ms.
same-sex.
Luthra, we've seen it. Thank you, Ms. Luthra.
Yes,
Thank you
Lord.
so much.
My lord, just if I may just end with E.D. Windsor, who was fighting for marriage rights for same-sex couples, and who said, there's a quote at the bottom, marriage is a magic word and it is magic throughout the world. It has to do with our dignity as human beings to be who we are openly.
Thank you, Mr. Speaker.
My Lord, I'm grateful, my lords. My Lord, I have also talked about workability in my note, as well as the interpretation of the various sections
Yes.
in point number 8, and how it has to be read in. We've already read in Harsova, we've read it in Gita Hare Haran,
All
we've
right,
read
yes.
it in
Thank you.
various
Thank you,
places.
Mr.
My
Luthra.
Lord, I'm grateful, my Lord.
Yes, Mr. Grover.
I'm grateful, my Lord.
Thank you very much.
And my Lord, grateful to my Lord Justice Bhatt and Justice Kaul, my Lord, for
But I'm going to be on a slightly different track. Lord, I want your lordships to comment to your lordships a slightly different argument borrowed from the US jurisprudence. And that, my lord, is on intimate association. That's one.
On the,
Intimate association.
yes,
My lord, I am representing two
Intimate
petitions, my lord, two petitions. One is under the Foreign Marriage Act, my lord, where the couple of Indian origin, one of them a citizen, they got married in the US, marriage is valid there, and they actually first came to India, both of them are Hindus, and they tried to register their marriage here, they could not. Then they went to the US, back to the US where they stay, and they actually went to the embassy, they filled all the forms. That was not registered. In fact, they were not treated very well. That is an issue. I don't want to get into that. The second petition is interfaith, Christian and Hindu, and obviously under the Special Marriage Act. I'm not going to repeat anything that Ms. Luthra said. I'll directly go on to an argument which has not been invoked earlier, Milan, and that is the argument of what is known as intimate association in the US, based on the 14th Amendment, 19th, and the First Amendment. And it would be embraced in Article 19(1)(c). The idea is that you can form associations from, say, cooperative societies to trade unions, which are larger groups, and intimate associations of a romantic or a marital nature. And that is a fundamental right in the US, considered to be a fundamental right in the US, coupled with free speech. Because in a larger association, you will actually have that group which will be protected by the right to associate, together with privacy, say, of their names, and also to express freely. That's the point. Now, so there are three issues, three concepts into one, but it is encapsulated in our constitution under Article 19(1)(c) (a), and obviously it will be subject to the reasonable restrictions in, as far as C is concerned, in 19(4) or 19(2). Now, this actually arose. I don't want to get into, in my note, which is a written submissions, I have given the history of it, but I'll just go into a couple of judgments, my lord, which your lordships are otherwise familiar with. Griswold versus Connecticut, my lord, is one judgment where the lordships in the Supreme Court, Justice Douglas's judgment, and he's written in the Columbia Law Review a paper on that.
This is part of your note?
Yes, article on that.
Okay.
It's a well-known
Is
Columbia
it the-
Law Review, my lord.
Yes, it is.
Mr. Grover, is it the second written note? You filed two,
Can you?
the first one or the second one?
additional one,
Second one, additional.
A to L, A to L.
Wait, ma'am. Lord, the PDF page 1269, volume 4. I'll just read that paragraph because this is an important paragraph. If I may read that.
It's running into 121 pages, your additional note, Mr.
I can't hear.
It's running into 121 pages. It can't.
No, no, I'm on the original volume 4, PDF 1269. I mean, there are so many volumes now, I've lost track of.
Precedents volume.
Yes, I've got that. Thank
Yes,
you.
my lord, Justice Bhatt is right.
Volume 4, page 121.
1269 is the last paragraph of Justice, the majority judgment of Justice Douglas. Lordships have it?
Yes.
We deal with the right of privacy older than the Bill of Rights, older than our political parties, older than our school system. Marriage is a coming together for better or worse, hopefully enduring, and intimate to the degree of being sacred.
Where did you get?
Sir, 129, internal page 486,
One,
Griswold
Sanjay?
versus Connecticut.
1 to
Volume 4,
Nine.
volume 4,
Yes, I got it.
PDF 1269,
PDF 1269. The original volume 4 compilation of judges.
1277.
1277, right? It's not
1269. No?
at 1277.
Mine is showing as 1269.
That starts at 1269.
I'm sorry, my lord.
Sister, it's at
This is called-
1269 with
My
me,
lord.
just before the concurring view of Justice Goldberg.
My lord is right. Obliged, you, lord. Grateful to my lord Justice Goldberg.
PDF 1277.
All right. But I'll just quickly read that. We deal with the right of privacy older than the Bill of Rights, older than our political parties, older than our school system. Marriage is a coming together for better or worse, hopefully enduring and intimate to the degree of being sacred. It is an association that promotes a way of life, not causes, a harmony in living, not political faiths, a bilateral loyalty, not commercial or social projects. It is an association for a noble, for as noble a purpose as any involved in our prior decisions, which are all about larger associations, etc. Now, my lord, this actually has been finally given a imprimatur by the Supreme Court in a famous case versus the Roberts versus Giacis, which is in that additional written submissions, my lord. And there, my lord, I'm not reading any large passages, but immediately, if your lordships have, if the court has page 7, lordships have the additional note that we sent last week. And in that, there is Robert versus Giacis, page 7. On the right-hand sides.
Under on intimate association.
My lord is absolutely right.
Subpara
Only
Roman
on
8.
intimate. I'm sorry, my lord.
Subpara Roman 8 refers to Roberts versus United States.
Yes, Sappa right.
Yes.
On the main judgment, my lord. So
Which page?
the personal affiliations that exemplify these considerations and therefore suggest some relevant limitations on relationships that might be entitled to this sort of constitutional protection are those that attend the creation of sustenance and family, marriage. The judgments are quoted. Family relationships by their nature involve deep attachments and commitments to the necessarily few other individuals with whom one shares not only a special community of thoughts, experiences, and beliefs, but also
Yes.
and beliefs, but also distinctively personal aspects of one's life. Among other things, therefore, they are distinguished by such attributes as relative smallness, a high degree of selectivity in decisions, to begin and maintain the affiliation, and seclusion from others in critical aspects of relationship. As a general matter, only relationships of these sorts of qualities are likely to reflect the considerations that have led to an understanding of freedom of association as an intrinsic element of personal liberty. Conversely, an association lacking these qualities, such as large business enterprises, seems report from the concerns giving right to this constitutional protection. Accordingly, the Constitution undoubtedly imposes constraints on the state's power to control the selection of one's spouse that would not only apply to regulations affecting the choice of one fellow's employees. Comparison. Between the poles, of course, lies a broad range of human relationships that make greater or lesser claims to constitutional protection from particular incursions to the state by the state. Determining the limits of state authority over an individual's freedom to enter into particular associations, therefore, unavoidably entails a careful assessment of where that relationship's objective characteristics locate it on the spectrum from the most intimate to the most attenuated of personal attachments. We need not mark the potentially significant points on this terrain with any precision. We note only that factors that may be relevant include size, purpose, policy, selectivity, congeniality, and other characteristics that in a particular case may be pertinent. In this case, however, several features of the JSAs clearly place the organization outside the category of relations worthy of this kind of constitution. In this case, this is association where women were sought to be excluded. Immediately next page, and I'll finish on this judgment. The first para on the left, an individual freedom to speak, to worship. So worship also is hour 25, to petition the government for the redress of grievances could not be vigorously protected from interference by the state unless a correlative freedom to engage in a group effort towards these ends were also not guaranteed. According protection to collective effort on behalf of shared goals is especially important in preserving political and cultural diversity and in shielding dissident expression from suppression by the majority. Consequently, we have long understood as implicit in the right to engage in activities protected by the First Amendment, a corresponding right to associate with others in pursuit of a wide variety of political, social, economic, educational, religious, and cultural. It's very broad, my lord. So while you can have an association, you also have protection in pursuing that. In view of the various protected activities in which the JICES engages, that right is plainly implicated in the case. So, my lord, it is now set. My lord, I am commending your lordships to also, apart from privacy, autonomy, and dignity, which we have read into 21, to consider whether we can actually use this. And, my lord, one author has said this is much more protective than like a 21 privacy. There's only one more.
What else, Mr. Grover?
My lord, next point I want to make is in Oberfell.
Sorry?
Obergefell, the judgment which actually recognized same-sex marriage. I remember, this is apropos what my Lord Justice Butt said. Lord, my argument is twofold. They have taken intimate association as one of the criteria. Secondly, my Lord, it was not a case that the core of the argument, the core of the case is not in holding invalid statutes which did not allow same-sex marriage. It is in fact flowing from the 14th, 9th, and the First Amendment and saying this is the right. And therefore, any restrictions have to be held to be not applicable. That is this. And, my lord, if your lordship will just go to Obergefell, and may lordship, I know that the syllabus cannot be used, but the syllabus is a very precise summary, and is by the court itself. And that is, my lord,
Mr. Grover,
my lords.
that's precisely the point I made, that it can be used only for the purpose of a declaration. So in the course of that, they said that there's a right to marriage. So in that, there are two parts. One is the declaratory part.
Yes.
The second is the consequential, or rather, the part.
I appreciate what my lord is putting to me. I agree with my lord, my lord. Only thing I want to add is that the core is not to strike down the statute. And if your lordships, I'll only point and not read out because it's lengthy.
No, you can't say that it wasn't. It was both. In order to say that there is that these are unconstitutional, first it was necessary to declare that there is a right to marry.
Lord, may I commend your lordships to actually go to the relevant portion, volume 4 again, 2399. I'm not going to read it, because time is limited. But there is the syllabus, and the syllabus is an accurate summary. And my lord, your lordships I will only read only a portion of that. But I agree with my lord. That was an incidental thing about invalidating statutes. That was not the core of the argument. So if your lordships have the time and will have the time to read the whole judgment, it'll become very clear. But my lord, if your lordships will just go to the page 2400.
Volume 4.
Volume 4 itself, my lord, 2399 it starts. And it's interesting what they say, my lord, the principle.
PDF 2408.
23, my ladies, some error. I'm so sorry. I don't know.
Okay, you're reading the physical page. We are pointing out the PDF is 2408.
My page is 2399, but my ladies' page will be slightly different, I think.
399 is
Obergefell versus Hodges,
what, yeah.
the syllabus. Lord,
Yes, we've got that syllabus.
Lord, there are pages on the top right-hand corner. I'm sorry.
You've got that. That's
Yes.
the physical page. It's okay.
Let's come to 2401, 4 principles. 4 principles and traditions demonstrate the reason that marriage is fundamental under the Constitution apply equal force to same-sex couples. The first premise of the court relevant precedent is that the right to personal choice regarding marriage is inherent in the concept of individual autonomy. Then your lordships will come to the second principle, and that's where I am coming in terms of intimate association. A second principle in this court's jurisprudence is the right to marry is fundamental because it supports a two-person union like any other in its importance to the committed individuals. The intimate association protected by this right was central to Griswold versus Connecticut, which held that the Constitution protects the right of married couples to use contraception and was acknowledged in Turner. Supra, the same-sex couples have the same right as the opposite sex couple to enjoy intimate association, a right extending beyond mere freedom from laws making same-sex intimacy a criminal offense. The third basis for protecting the right to marry is that the safeguards of children and families and thus draws meaning for the related rights like childbearing. Then your lordships will come down to the bottom of that page. This does not mean, as your lordships put it, you don't have to have children. This does not mean that the right to marry is less meaningful for those who do not or cannot have children. Precedent protects the right of a married couple not to procreate so that the right to marry cannot be conditioned on the capacity or the commitment. Finally, this court cases and the nation's tradition. Your lordship knows in US the traditions are very, very important. Now, my lord, so I'm commending your lordship to actually use this doctrine of intimate association. That's the point, my lord. Now, my lord, second point I want to go into is about transgender people, my lord. Now, my lord, there has been a lot of confusion about norms, the gender glossary. So I'm just giving one glossary. Just give it. We'll be sending it to your lordships, my lord. I'm very sorry that we didn't know that. Resources. Lord, this is just the glossary. Your lordships are now. Your lordships got it. I don't know how to give it. Just send it. How will you send it? You can email it. You just email it. Lord, here I want to, your lordships, to go to NALSA judgment, which is in volume 1. What I want to say is, my lord, in the affidavit filed by the Union of India, unfortunately, my lord, they seem to be of the opinion and impression that in ancient India, up to the advent of the British, we did not have non-heterosexual relationships. This is completely incorrect. And there are tomes and tomes of literature now available which shows that these relationships were prevalent. They are not only prevalent, but scriptures actually record it. So I'll only refer your lordships, the court, to certain distinct, but please see NALSA. NALSA is in volume 1 and paras 13 to 20, because this was argued by us in NALSA, and that's why ultimately they said It is part of our tradition.
Para?
Unlike in Europe, in that sense, Europe was backward.
13.
Time to the British, we already had the notion of Tritya Prakriti. It was part of our tradition. And in terms of marriage, marriage between non-heterosexual couples, transgender and transgender, transgender and cis male, transgender and cis female was common. And it's actually noted in our scriptures also. Now, volume 1, my lord. I'm coming to Ruth Vinita later. Paras 13, my lord. Just see this. And my lord, I'm sorry to say to refer to transgender in a derogatory manner is completely unacceptable. And that was the British notion, not an Indian notion. Unfortunately, my lord, right after the British, we ourselves, people like us, the middle class, upper middle class, have imbibed that prejudice. We have to get rid of it. Even today, it is actually prevalent. But para 13, and the notion of transgender is an English term. We had other terms, hijra, chokapa, koti, etc., where a person would actually take on another gender physically. But in terms of, my lord, thinking, in terms of theory, and this is in the Nalsa judgment, my lord, the Buddhists and the Hindus construed this as a physical parameter. Whereas Jains, in their scriptures, consider that as a psychological parameter. So in the 13th and the 14th century, we were much more ahead in thinking than the Europeans. To argue that we didn't have this in our country is completely incorrect.
Just for appearance.
Go through that. Paragraph 14 talks of the various diverse communities of transgenders, Hijras, eunuchs, Kotis, Aravanis, Jokapas, Shiv Shaktis. Then please see paragraph 15. Lord Rama in the epic Ramayana was leaving for the forest upon being banished from the kingdom for 14 years, turns around to his followers and asks all men and women to return to the city. Among his followers, the Hijras alone did not feel bound by this direction and decided to stay with him. Impressed by their devotion, Rama sanctions them for the power to
read that. Yes, we
Para
get your point.
I'm not going to read it now. All I'm saying is that this is well known. It is now incorporated in a judgment. I'm not relying on literature. It's incorporated. And please see para 17, which I was referring to. Jain texts make a detailed reference to transgenders, which mentions the concept of psychological sex. That's why Nalsa then actually incorporated these notions and said a person can actually be born as a male and he can say from tomorrow, psychologically I'm a woman, I'll assume the woman form, and it is his or her right, autonomous right, to assume that form. It is not through the intervention of the state. That's what Nalsa says. Ultimately, my lord, your lordships have the Transgender Act. And the Transgender Act actually under section 4 confers, 4 to 7 actually confers the right. And my lord, it gives protection to those persons who are actually certified to be transgender under that act. But you can first be a transgender, then you can assume the male or the female form through certification. Now, very importantly, my lord, what has happened is, just see this. If I am a male person, cis male, I marry a woman, cis woman, my marriage is valid according to the law. During the subsistence of the marriage, I actually assume a female gender, either through transition or otherwise. The law does not say that the marriage becomes void or voidable. In fact, it recognizes it under the Transgender Act and the transgender rules. That is the state of affairs under the present law. And secondly, my lord, certain states, including Kerala, and I've given that form, my lord, they are encouraging, I've got the translated, my lord, I have to translate that. They are encouraging people who are married and they're actually being financed so that they can actually. So states are recognizing these marriages.
Have you read,
But I don't have much time. I don't want to, I'll stick to my time.
you have read and understood this?
I'm sorry.
You read and understood this?
I'm sorry, I can't.
It's in Malayalam.
No, there is Malayalam and English.
Translation, sir.
You know, Lordship doesn't have the English one.
No, you gave the.
Give the English one, please. We have to translate it from an advocate practicing in this court, my lord, who understands Malayalam very well. Yeah.
But there might be some considerations there. Because if there is an existing marriage,
My lords.
and that existing marriage has resulted in, let's say, children and a family, this kind of, if this is not preserved, that will lead to perhaps that some untoward adverse consequences to members of that family.
Your lordship is absolutely right. But at the same time, one could also envisage a situation where the legislature would have said that no, it's void or voidable. Because if you
The
change
point
your
is,
religion,
then,
right?
then you're looking at a legislature which doesn't take into account realities, no?
I
So
agree.
here there is, it's a different kind of reality which you are wanting the legislature to take care of. Whereas that's
Yes.
another situation where the parties have, a certain something has happened which they don't want it to result in consequences, which is not of the making of the other parties who may be deemed innocent or whatever. We don't know.
Ordinarily, suppose a person actually reassigns his or her gender in a marriage, the other party would say, I want to divorce you. The legislature has not taken that view. The legislature has actually
That too is
taken,
an assumption. That too is an assumption based on, with all due respect, certain classes. Because if you do that in a certain community, you may lose your status. We don't know how things work out. It's a very plural and diverse society.
very well, that's one of the issues that.
Justice Call, would you want to take a little break, a 5-minute break or something?
No,
I'll finish in 2 minutes, my lord.
I'm good, Justin. So for the time, I'm good. I can continue if you want.
All right.
My lord, I won't take much time. I'll finish in the next 5 minutes. The third point I want to make, my lord, is that there has been argument on the other side that it is for Parliament to legislate on this issue. But let us look at
Yes.
let us look at the record. Issues have been coming up, and I have given, my lord, a document by what is known as the Pink List India. They have been actually observing and monitoring what is happening to LGBTQI issues in Parliament. And there has been no positive response for the last 5 years, my lords, on doing anything positive about this issue. So, can we expect, my lord? And in Obergefell, this was another issue. I didn't read that part. They also were told by the respondent states that we should wait for Parliament. And they said, no, we are not going to wait because the Parliament has disclosed its hand earlier, or rather the US Congress did. And the final point I want to make is about the so-called elitism. There are a large number of people are actually running away from their homes, couples, same-sex couples, they run away from their homes, and orders are available on the net. And we have compiled about 10 orders, and if your lordships will actually look at those orders, the origins of those people are from small towns. They are not from Calcutta, Delhi, etc. They are from very small towns. They come to the capital city where the High Court is, and they need protection. Right now, my lord, there's a case going on that I'm handling, where 2 women have come to Delhi from a rural area. And that those 2 people have no place to stay. They are poor people. They don't have the money. If you have the money, you can afford to hire lawyers, etc. But most of the people who are runaway couples, same-sex couples, are poor people. They are coming from small towns. They come to the main city in the state because the High Court is there. So I've actually compiled those orders, and if Lordship only looks at the facts, it's anecdotal, it's not completely methodologically correct, but it would be evident they're not elitist. So therefore, my lord, this notion that this is elitist is incorrect. But I am sticking to my time. I'm much obliged. Oh, no, Lord, only 1, 2 things. No. Lord, there is, in my written submissions, just go to that now. In my written submissions, I would be not doing my duty, as it were, if I did not read that portion. Lord, there's a poem which I'll commend your Lordship reading, that in the beginning. Lord, this is interesting. It's from Khalil Gibran. Then Almira spoke again and said, "And what of marriage, master?" And he answered, saying, "You were born together, and together you shall be forevermore. You shall be together when white wings of death scatter your days. Aye, you shall be together even in the silent memory of God. But let there be spaces in your togetherness, and let the winds of heaven dance between you. Love one another, but make not a bond of love. Love one another, but make not a bond of love. Let it rather be a moving sea between the shores of your souls. Fill each other's cup, but drink not from the same cup. Give one another your bread, but eat not from the same loaf. Sing and dance together and be joyous. But let each one of you be alone. Even as the strings of a lute are alone, though they quiver with the same music. Give your hearts, but not unto each other's keeping, for only the hand of life can contain your hearts. But I only want to say that this would have not been possible for me, were it not for Justice A.P. Shah, Justice Muralidhar, and your lordships in the Navtej Johar judgment, and my mentors, Justice Kirby and Justice Kamra. Thank you.
Thank you, Mr. Grover. So we'll now have the arguments of Ms. Jaina Kothari.
Please, my lords, may it please the court. My lords, I appear in the matter of Dr. Akkai Padmashali and others versus Union of India, my lords. I have submitted supplementary submissions, which is a 5-page note. It is there in the written submission folder, but I also have some copies, my lords, which I...
What would you be, what's the point that you're going to...
My lord, this is just a more summarized version. That's all for today, since I just have 20 minutes. It's called, my lords, supplementary submissions. It's a 5-page...
Yes, I got it.
...which I have submitted. And if my lords, Justice Kaul and Justice Bhatt also have it.
Yes, we've got it.
Grateful. It's grateful. Yes. My lords, I have 3 points to make, and I'll stick to my time. My lords, our first claim, My lords, this is the second petition for transgender persons. The only other petition was by Mr. K.V. Vishwanathan of Zainab Patel. My lords, our claim here is for marriage equality for all, not just same-sex marriage, my lords. We are seeking that there should be marriage for all persons, irrespective of gender identity or sexual orientation. And that is our fundamental claim. And I pray, my lords, that that claim or that framing be given to this matter, my lords. My lords, the first issue, very briefly, because it has been covered, is on transgender persons' right to gender identity. I'm not going to labor it much. But my lords, some points need to be clarified. My lords, trans persons are persons whose gender does not match the sex assigned to them at birth. So therefore, they may be born as male or female, and whatever sex may be assigned to them at birth, but they identify with a different gender. And therefore, under NALSA, this gender identity and the right to self-determine one's gender identity was protected by this Honorable Court. And this Honorable Court held that it is not only two genders, not just male or female, but male, female, or transgender. You could identify with either any of those gender identities, even without medical reassignment. And the purpose, my lords, of granting this right to self-determine one's gender identity is to get legal recognition to a whole bunch of other rights. It could be the right to vote, it could be the right to get a driver's license, including the right to marry, which was read out. And I've written the para numbers. The right to marry of transgender persons also was specifically recognized under NALSA. My lords, in practice, what happens is that despite the recognition of one's gender identity, trans persons, my lords, are unable to exercise their full legal rights for many reasons. One, that despite NALSA, they still have to undergo medical reassignment to get their documents changed. A large number of them are not able to do that. And unless they get their medical documents changed, they don't get access to a whole bundle of rights. In fact, technically, one could say that under the Special Marriage Act, if you come within a man or woman technically and have documents to show that, you may even be allowed to marry. But my lords, how many persons are even able to do that? And what about persons who identify not as the binary genders, but as transgender? There is no coverage of that. Yes. And my lords, there are intersex persons as well, and which are not covered at all. My lords, my second point is on the right to family. My lords, the right to family, that is my second main point, the right to family to be recognized under the right to life under Article 21. My lords, the petitioner, Dr. Akkai Padmashali, she was born male. She faced so much violence at her parental home and family that she had no other option but to leave her home when she was about 14, 15 years old. She was on the streets without her family, begging and into sex work. That is, my lords, what a majority of transgender persons have no other option but to do when they are forced to leave their homes. And therefore, my lords, what does the right to family mean? My lords, the right to marry in this case, what we're asking for the Special Marriage Act to cover. The right to marry has been upheld in a whole variety of judgments of my lords. There's Shakti Vahini, Shafin Jahan, and all of that has been read out. But my lords, the right to marry gives rise to a family, a kind of family. which, my lords, is also a fundamental right and has to be recognized under Article 21. My lords, we can have families by blood, marriage, adoption, but marriage is one way in which we have a family, and an important way. Couples can decide to marry and not have children. Couples may decide to have children. And then their family unit is either the two spouses or with their children. And my lords, what does a family do? My lords, it goes to the core of our being. I read out, having the love, care, and support of a family is an essential ingredient for a person to live a full life. My lords, our families give us not only love and care, but they give us psychological support. They give us economic support. Our family is the only unit. It is the basic unit in society that we turn back to when we are in any kind of trouble. And my lords, therefore, do we not have the right to have our family recognized and the right to form our family, my lords? And that is the right I'm asking has to be recognized under Article 21. My lords, trans persons are already having their families. They are in long-term relationships, they are adopting children, and they are maintaining their families. But these families are not recognized because, my lords, marriage is not permitted. And therefore, my lords, family is not just a heterosexual phenomenon. My lords, the importance of the family as an integral part of one's personality has already been recognized to some extent under the right to privacy. And my lords, if I may just, I've extracted a couple of paragraphs, and my lords, that's in my note in para 9. May I please refer to those paras, my lords? That's para 271. It's in my notes, so my lords may not have to take the trouble of referring to the Puttaswamy judgment. Para 271, my lords held, we need also emphasize the lack of substance in the submission that privacy is the privilege for the few. Every individual in society, irrespective of social class or economic status, is entitled to the intimacy and autonomy which privacy protects. The sanctity of marriage, the liberty of procreation, the choice of a family life, and the dignity of being are matters which concern every individual, irrespective of social strata or economic well-being. The pursuit of happiness is founded upon autonomy and dignity. Both are essential attributes of privacy, which makes no distinction between the birthmarks of individuals. Therefore, my lords, marriage, procreation, family life choice are all separately referred to, my lords. Then, my lords, in para 298, it follows, my lords. The intersection between one's mental integrity and privacy entitles the individual to freedom of thought, the freedom to believe in what is right, and the freedom of self-determination. When these guarantees intersect with gender, they create a private space which protects all those elements which are crucial to gender identity. Specifically in the context of gender identity, my lords held, the family, marriage, procreation, and sexual orientation are all integral to the integrity of the individual. Above all, the privacy of the individual recognizes an inviolable right to determine how freedom shall be exercised. And lastly, my lords, in the same judgment, Justice Call's referral in para 645. It is an individual's choice as to who enters his house, how he lives, and in what relationship privacy of the home must protect the family, marriage, procreation, and sexual orientation, which are all important aspects of dignity. My lords, recently, my lords, in the Deepika case, in fact, refer to unconventional families. My lords, we are dealing with unconventional families and have recognized them. And it is not just the marital tie, but what is the concept of family? And my lords refer to, and I will just read out one para 26. The predominant understanding of the concept of family, both in the law and in society, is that it consists of a single unchanging unit with a mother and a father who remain constant over time and their children. This assumption ignores both the many circumstances which may lead to a change in one's familial structure and the fact that many families do not conform to this assumption to begin with. Familial relationships may take form of domestic, unmarried partnerships or queer relationships. Household may be a single parent household for any number of reasons, including the death of the spouse, separation, or divorce. Similarly, the guardians and caretakers who traditionally occupy the roles of the mother and father of children may change with remarriage, adoption, or fostering. These manifestations of love and families may not be typical, but they are as real as their traditional counterparts. Such atypical manifestations of the family unit are equally deserving not only of protection under the law, but also of the benefits available under social welfare legislation. The black letter of the law must not be relied on to disadvantage families which are different from traditional ones. So therefore, my lords, I ask, should families where persons are trans or of a different sexual orientation, can they be denied of the right to have a family life? And my lords, interestingly, the Delhi High Court, in a 2021 judgment in Lakshmi Bhavya Taneru, this was in the case of a heterosexual couple which didn't have children. They wanted to be together. And the court, in fact, for the first time held that this would come under Article 21, and I would read out, my lords. We have no doubt the right to a meaningful family life, which allows a person to live a fulfilling life and helps in retaining her or his physical, psychological, and emotional integrity, would have a place in the four corners of Article 21 of the Constitution. My lords, is a family different just because your gender identity is different? Are these not the same values that all of us want at the end of the day? And so therefore, my lords, I argue that this should fall under Article 21. And my lords, this has been recognized in European jurisprudence and in some of the international treaties. And I've just had a reference of these for my lords' reference. My lords, the Universal Declaration of Human Rights, the 1948 document, while it refers to men and women because gender identity was not an issue at that time, it still recognizes under Article 16, men and women of full age without any limitation due to race, nationality, or religion have the right to marry and to found a family. My lords, that's what I want to insist on. They are entitled to equal rights to marriage, during marriage, and its dissolution. The ICCPR, my lords, in 66 held under Article 23(1), the family is the natural and fundamental group unit of society and is entitled to protection by society and the state. My lords, we have signed up to ICCPR. The right of men and women of marriageable age to marry and to found a family shall be recognized. And my lords, the European Union, of course, has separate fundamental rights on this. The Charter of Fundamental Rights of the EU, my lords, in Article 9 holds all persons have the right to marry and the right to found a family. And the European Convention on Human Rights, my lords, Article 8 and 12. Article 8 states that everyone has the right to respect for his family and private life, his home and his correspondence. Article 12 states that men and women of marriageable age have the right to marry and to found a family according to national laws governing the exercise of this right. My lords, the Yogyakarta principles, which were relied upon by this honorable court in Nalsa, in fact, has a specific article on the right to have a family in the context of marriage. And my lords, that is principle 24, which I have extracted. Everyone has the right to found a family, regardless of sexual orientation or gender identity. It reiterates what my lords, in fact, said in Deepika. Families exist in diverse forms. No family may be subjected to discrimination on the basis of sexual orientation or gender identity or of any of its members. And it, in fact, calls for states to ensure that laws and policies recognize the diversity of family forms and to ensure that in states that recognize same-sex marriages or registered partnerships, any entitlement, privilege, obligation, or benefit available to different sex married or registered partners is equally available to same-sex married or registered partners. My lords, there are two decisions. I will not go into those, but my lords, O'Leary and others versus Italy, this was an issue where same-sex marriage was not recognized in Italy, and the court held that the denial of recognition of same-sex marriage amounts to a violation of their right to family life. And my lord, in Christine Goodwin versus UK, this was a case wherein, my lords, the European Court of Human Rights held that transgender persons do have the right to marry, and that flows from the fundamental Article 12, which is the right to found a family. And therefore, my lords, I would argue that we have to recognize that there is a fundamental right to family under Article 21, and in order to exercise that, the right to marry has to be granted. My lords, finally, of course, the Special Marriage Act and the manner in which it is construed presently by focusing only on men and women denies transgender persons the right to marry and have a family solely on the basis of their gender identity. That, my lords, amounts to a 15(1) discrimination on the basis of sex. My lords, before I go on to just my last para, I have given a proposed reading of the Special Marriage Act, which replaces men or women with persons or spouses. It's for my lord's consideration. It's there. It's in fact on the last page of the submission. Page 6, it is at the end of the submission. And my lords, so therefore my submission is that all references to male or female be read to as persons, and all references to husband or wife be referred to as spouses, to include all persons, irrespective of their gender and sexual orientation, and I have given a formulation of that. My lords, I want to just end with a reference from Navtej. My lords, ultimately, these issues of marriage rights, my lords, our argument is that it is marriage rights for all. These amount to ensuring that all of us have equal marriage rights, not just one group or the other. And my lords, this was, in fact, reiterated by my lords in Navtej. And if I can just refer to the last para, my lords, that is para 425, and I have quoted it. The struggle of citizens belonging to sexual minorities is located within the larger history of the struggles against various forms of social subordination in India. The order of nature that Section 371 speaks of is not just about non-procreative sex, but is about forms of intimacy which the social order finds disturbing. This includes various forms of transgression, such as intercaste and intercommunity relationships, which are sought to be curbed by society. What links LGBT individuals to couples who love across caste and community lines is the fact that both are exercising their right to love at enormous personal risk and in the process disrupting existing lines of social authority. Just thus, a reimagination of the order of nature as being not only about the prohibition of non-procreative sex, but instead about the limits imposed by structures such as gender, caste, class, religion, and community, makes the right to love not just a separate battle for LGBT individuals, but a battle for us all. My lords, that's what I would
reflecting. Yes.
Therefore, my lords, I submit that these are issues that need to be addressed, and I pray that.
Thank you, Ms. Kothari. Thank you.
My lords, I have also submitted, I won't go into it, I've submitted an article from the Cardozo Law Review on the right to family relating to same-sex relationships. It is there for my lord's reference. I leave it at that.
Thank you, Ms. Kothari.
Very grateful.
Our brothers, Brother Call, Justice Brother Bhatt, we have about 4 minutes left. Should we come back after lunch and hear Ms. Dr. Guruswamy after lunch, if that's all right with both of you?
Yes, I think that's better because she is to take about 30
We'll
minutes.
have, exactly.
Together, so it'll give a better.
So, Dr. Guruswamy, we will hear you after lunch.
Grateful, my lords. Grateful.
Grateful, my lords.
You brothers after lunch.
Okay, thank you.
Thank you. Yes, Dr. Guruswamy.
My Lord, Justices Bhatt and Justice Kaul is here, my lords.
Yes, Justice Kaul is joined. And yes, Justice Bhatt is also on screen.
My lords. My lords, may I say that that was the most nerve-wracking lunch of my life.
Why is that?
Because, my lords, I was thinking about how do I sum up a conversation that perhaps Mr. Kripal, Ms. Kaju and I have contemplated having in this court for perhaps many decades of our life. That is why. So I went high on sugar and low on carb, my lords, at lunchtime. My lords, I am not going to belabor or repeat any point, and I assure you that. But I am going to make 5 submissions. My submissions have been substituted, as my lord knows that this is a different act. So these submissions are with regard to writ petition civil 1141 of 2022, Ms. Aditi Anand and others versus Union of India, challenging the Special Marriage Act. I also appear, my lords, today for DCPCR, the Delhi Commission on the Protection of Children's Rights. And their IA is 71983. Now, I will make 5 distinct points on the writ petition, and I will make 2 very short submissions on DCPCR's intervention. My lords have my substituted submissions, my lord.
Yes.
So this will do instead of the.
Yes, my lords. It's a substitution.
Comprehensive.
It's not an ancillary, it's a substitution.
Yes, you got it.
There are long annexures because we did not have benefit of the compilation since this is a substitution. My lords, my 5 distinct points are one, this. Contrary to what the union has advanced in its counter and in its opposition in court, India's parliament, in India, the parliamentary form of government that we adopted as we the people when the constitution was adopted, unlike England, is a constrained parliamentary form. In England, parliament is sovereign. In India, simply put, parliament is constrained. Constrained by what? Constrained by the constitution as interpreted by whom? My lords. That is the separation of powers formula we the people gave ourselves. So to say that this is a matter for parliament is not just unknown to the Indian parliamentary form, which is constrained by the constitution, seeks to impose these petitioners in 19 petitions, speaking for, if arguably 5 to 7% of any country's population identifies as LGBTQ, then speaking on behalf of millions of Indians, come to my lords to say this and this alone, that our Article 32 right, and as my Lord the Chief Justice said, most importantly in this preamble, that we the people gave ourselves, the people of India having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens. That's 32. So the government of India cannot come to court and say that we the people, and we may be a minority or a substantial part of this population, cannot come to court and say that this is a matter of parliament, because our Article 32 rights, the right of judicial review, is part of the basic structure of this constitution, of which this basic structure doctrine we have now celebrated 5 decades. Those 5 decades belong to LGBTQ people also. My lords, point 3. And again, I will only take my lord to the specific paragraphs.
What is the point 2?
My lords, point 2 is Article 32.
All right, that's all.
Yes, my lords. Is point 2. And I'll take my lords. That's also the second point of the written submissions, my lords. My lords have the index. So I won't trouble my lords with repeating any points that have been dealt with. My Lady Justice Kohli has the index also, my lady.
Yeah.
I'm grateful. Point 3, my lords. The union in its counter has said to us that they have a legitimate state interest in prescribing this nature of marriage. My lords, the Chief Justice, 9 judges in Puttaswamy, have interpreted legitimate state interest as specifically pertaining to national security, crime, innovation, and dissipation, prohibiting dissipation of social welfare benefits. That is the understanding of when can the state ascribe and highlight such legit. This is point 3. Nowhere in these cases, in these petitions, does the state meet that heightened requirement. I'll take my lords to the 2 relevant paragraphs there, which are also in my written submissions. That is point 4, my lords. In response to earlier questions on day 1 and day 2, we discussed that marriage was a bouquet of rights. And what is that bouquet of rights? The table of benefits, my lords. Very briefly, part of the written submission, so I won't belabor it. But these benefits include gratuity, provident fund, and my lords, dare I say, pension of judges, including Supreme Court judges, are all premised on the understanding of one thing and one thing alone: a spousal relationship created by marriage. We are excluded from all of that. That is my table of benefits at page 35 of the written submissions. That is point 4. Point 5, my lords, that marriage is a matter of conscience under Article 25 of the Constitution of India. Now, my lords have heard arguments on Article 14, 15, 19, 21. They are all extracted in my submissions. I adopt my comrades at the bar who've advanced those arguments. I'm not going to repeat them. They're part of my written submissions. But marriage is also a matter of conscience under Article 25 of the Constitution. And that is my point 5. Finally, my lords, there is a workability table. I will not trouble my lords, but just to say that it is part of the submissions. But the final point I want to say, and I will come back to this also when I deal with the submissions of the statutory body, that is DCPCR, is that our Annexure 6 in my submissions is the only study that is based in India. It has 5,800 respondents, and the study speaks to 1, the journey post-Johar, how it has impacted LGBTQ people, and 2, how marriage equality will impact LGBTQ people. And that is a substantial portion of the annexure that is part of these written submissions. I couldn't put it in the compilation because at that time I was on a different brief. And of course, my lords knows that the Indian Psychiatric Society has also released a statement commending marriage equality. My lords, may I first take you very briefly to the first submission, my lords. And I will only read very specific paragraphs, and I will not trouble my lords beyond that. That the Indian Parliament is a creature of the Constitution and does not enjoy unfettered sovereignty. May I only take you to one paragraph, my lord? And this is, my lord, as part of my written submission, page 6, para 11. Just page 6, my lord. Just one paragraph of my submissions.